kind introduction, and I'm so happy to see so many interested people in this topic. I thought that I'm the only one. Dear colleagues, what can I say? Even though I'm not a criminal lawyer, I like to say that I deal with the two biggest thefts in history. The first is nationalization, and the second one is privatization. I don't, this is not completely true because I deal with restitution, so reprivatization, and reprivatization of church properties in some selected countries of Central Europe. Latvia is not one of them, but I was very interested in hearing your presentation though. To understand what I mean by restitution, I would like to define it, and I would paraphrase Professor Veres from here, who considers, and I agree with him completely, that restitution is only one of the legal means of dismantling a dictatorship in this part of Europe where dictatorships formerly existed. It's one of the transitionary justice measures with which one can transition to a market based on free economy from a planned economy. And to see clearly why I choose this topic, you must understand that the restitution is still an ongoing process in Romania. And from this, many smaller questions can arise. These are my main questions, but there are 4 questions, to be honest, in total. The first question is regarding how did these property regimes of the churches look like before the nationalization era. I'm also interested in the why, how, and when of nationalization, the why, how, and when of reprivatization, and how these different models which the countries adopted affected the outcomes of these reprivatizations, basically. And I would like to share with you the story of Romania. We Eastern Europeans most probably are familiar with the Marxist maxim that the religion is the opium of the people, I believe. Another thing about Marxist philosophy is that it does not like private property, or at least not much of it, called capital. Marx famously stated in his Communist Manifesto that if he would have to subsume the essence of communism in one phrase, that would be the abolishment of private property. And this kind of anti-clericalism and also dislike for the so-called exploiters is what led to the nationalization of church properties in every country, which fell under the influence of the USSR, and it happened everywhere according to the Stalinist model, of course. Romania's case is no different. I'd like to share with you how the general secularization policy affected the church-founded school system, how it was annihilated. First of all, new constitution is enacted in 1948, allowed for the possibility of exploitation for the means of production in general, but also the same constitution forbid the churches from maintaining any schools. Later on, but in the same year, 2 ordinances were adopted, one after the other, very rule of law-like ordinances. The first was called on the reform of education, which generally stated that all private schools will be taken into state property. And the second ordinance was about, it expressly listed the properties which were taken over by the state. Then this resulted in the confiscation of 2,140 real estates in total. To understand why this is important from my perspective, I must reiterate what Professor Jukic already said, that religion and ethnicity in Romania largely overlap. I come from the Hungarian minority, and the Hungarian churches Hungarians had separate churches and have separate churches in Romania up to this point. And as somewhat autonomous entities in the interwar era, they were responsible for maintaining the institutional framework of the minority. What I mean by this, they maintained schools, they maintained nurseries, they maintained basically nearly every social institution you can imagine. So the biggest losers of this nationalization process were the ethnic minorities. These are numbers and facts, but to make it somewhat more personal, you can see on this picture, this was the school I studied in, or the building. It was the Reformed Church Calvinist Church's school, and restituted and later on renationalized. Remember it because it will be important later on in the presentation. When it comes to restitution, going back to the first thought in the introduction, we must say that it corresponds in legal terms to reprivatization, because after the fall of the Soviet-type regimes in this part of Europe, the necessity to split the former state property, of course, arose as a vital issue. And it had two modalities: privatization, which referred to industrial property, which had to be privatized. And when it comes to reprivatization, this is a form of historical reparation, where the former properties are given back to the former owner or its legal successor. And the big question which comes up when talking about reprivatization and privatization, to which extent we should allow it to disrupt the economic continuity of a state? Where can we find the balance? And in those in your presentations, in the presentations of my colleagues earlier, we could hear lots of terms regarding the different types of restitution. Restitution can be integral, restitution integrum, we give everything back or only partial, can be done in kind or in compensation, or the combination of these two. Just immovable assets can be given back, or movables as well. And to understand the case of Romania, we must mention that when it finally embarked, after a very, very long reluctant period, finally embarked on the process of restitution, it adopted basically the costliest restitution there is, in integrum restitutio, with compensation as well in exceptional cases when the properties cannot be returned in kind, with movable property if it exists as well. And most probably this is one of the main reasons why the restitution process halted later on. Yes. Before explaining how we got in this situation, I would like to introduce you to what I like to call the legislative octopus of Romanian restitution legislation. From the 90s onward, early 90s onward, there were a lot of regulations regarding the restitutions to private owners. But when it came to communal property, the churches and minorities had to wait until 98 for such government emergency ordinance. This is what GO means. It's an administrative act with the power of a law, which gave back communal properties for the first time. But imagine it in the sense that, for example, the first government emergency ordinance listed, second one listed here, the 112 from 98, gave back, for example, only 4 properties. It listed 4 properties and it gave back to the minorities and minority churches 4 properties in total. If you observe one extra interesting thing when it comes to the restitution of church properties, which are the government emergency ordinances and acts on the bottom, you can see that they are all prior to the EU accession of Romania, this being one of the main stimuli for the whole restitution process, basically. And we must understand this process in a way that from complete reluctance, Romania changed to in integrum restitutio, and this change basically happened in the years between 2002 and 2005. First of all, a government emergency ordinance was adopted in 2000, number 94 there, which referred to all churches, not just minority churches or minority institutions, and that was the basic rule for the restitution of church properties. Even though it specifically listed properties, the list was opened later on by the act, by the law of parliament, which was adopted based on this government emergency ordinance, which changed the whole philosophy of restitution from not giving nearly anything back to let's give everything back. When we see the conditions which had to be accomplished by the churches to give their property back, we see in the laws that there are four main conditions. That the property had to be nationalized from the churches, or this is important because, for example, in Hungary we hold in Pope Zsófia's presentation that also foundations of certain churches can reclaim properties, not only the churches or the cults itself, as the law calls them. The restitution must be asked by the church's successor. The property must be in the property of the state or some kind of administrative unit, the same kind of condition as in Hungary. It had to be accoperated by the state through abusive nationalization with or without a valid title, which is quite interesting, and what is also different from the case of Hungary, that the time scope of the rules regarding restitution is a little bit larger. It does not concern the period from 48 till 89, but the period from 45 till 89. And also in Romania, one more interesting fact, no church buildings could be given back. I mean the buildings, synagogues, and basically churches where the ceremony happens. Yeah, later on, to conclude this, all the regulations regarding church restitution were incorporated in law number 2005 247 from 2005, and the restitution of religious properties was regulated to two sub-statutory regulations, two government decisions related to this same law. This same law also established compensation as a means of dealing with the historical injustices. Okay, and now we come to the final presentation, final part of the presentation, which regarded my inquiry into this topic. In 2012, a paradigm shift happened. Until 2012, slowly but surely, a lot of church properties were given back to their former owners. From 2012 onwards, without not being any change in the legislation, these restitutions halted, stopped. Only a minimal part of church properties is given back from this period onward. Before this, nearly every claim of the churches was fulfilled. And this is marked by the case of my school, of Székely Mikó Collegium, which was renationalized, given back to the church, and then renationalized in criminal proceedings by a court decision, basically. And this marked the watershed symbolically. And I want to share with you why the restitution process failed in Romania. These are, I think, one of the most important factors. You've seen the regulation. It's an inept regulation. Like when we saw the presentation about Hungary, 2 acts in total. Compared to this, this is really not something I would like to deal with. Yes. Also, the commission, the committee, which was responsible for giving back these properties, was made in a way that it met up only rarely and could discuss. It had too much job to do, basically. It was a 7-member committee and had to decide on all restitution issues. And also the legal character of these commissions' decisions are somewhat debated, as they have an administrative character and they can be attacked in the administrative court and not in a civil court, and therefore the proceeding is different, and it allows not such a high-end protection as a civil proceeding would do. Yes, but the most important reason why restitution failed, basically, is that Restitutio in Integrum, even though adopted by the Romanian legislature in 2002, was too costly, and no political will was behind it, or it evaporated after the EU accession. Must be mentioned that the decisions of this committee, which restituted many buildings, can be attacked in court, and they are most often attacked in court by the administrative units or by the state, the former owner of the properties, and the courts most often favor the state over the former church owner. To conclude, I'd like to say that restitution was and always is a politically very contingent process. And as we could see from the presentations, there was no common recipe when it came to this transition period. I think every country which had to shift its economic model had lost and is a loser of the transition process. You can't become richer exiting the restitution process as you entered it. But I also believe that when it comes to restitution of church properties, there are bigger losers than the general losers in the region. And I believe the winners of the restitution process are the countries where, of course, the restitution process finalized, and where in the early 90s there was some kind of agreement based on mutual concessions between the state and the church, and where this reconciliation could happen. And the countries where it could not, of course, this is still an ongoing issue and causes a lot of legal uncertainty. I would like to leave you with 2 thoughts. I think generally the restitution of religious property is an issue of religious freedom, and in the case of Romania, delaying the justice based on the positive current regulation is only denying the justice. Thank you for your attention.